Consanguinity is the property of being from the same kinship as another person. In that aspect, consanguinity is the quality of being descended from the same ancestor as another person. The laws of many jurisdictions set out degrees of consanguinity in relation to prohibited sexual relations and marriage parties, or whether a given person inherits property when a deceased person has not left a will. Rules of consanguinity are also used to determine heirs of an estate according to statutes that govern intestate succession, which vary from jurisdiction to jurisdiction. The degree of relative consanguinity can be illustrated with a consanguinity table, in which each level of lineal consanguinity appears as a row, and individuals with a collaterally consanguineous relationship share the same row. The knot system is a numerical notation that defines consanguinity. Legal definitions. Modern secular law issues of consanguinity arise in several aspects of the law. It is directly relevant in determining whether a couple can marry. These are linked to a jurisdiction's definition of incest, so that couples in an incestuous relationship will not be permitted to marry. Some United States jurisdictions forbid first cousins to marry, while others limit the prohibition to any direct ancestors or descendants, as well as siblings, half-siblings, aunts and uncles. However, marriage with aunts and uncles is legal in Argentina, Australia, Austria, Brazil, France, Malaysia, and Russia, among other places in the world. Several volumes of Smith's Laws, enacted from 1700 through 1829, contain certain public and private laws of the province and Commonwealth of Pennsylvania. Consanguinity is also relevant in issues of inheritance. In regard to the law of intestate succession, under the Uniform Probate Code of the United States Section 2 to 103, after a surviving spouse receives his or her share, the descendants receive the remainder of the intestate estate. If there are no children, the decedent's parent receive the remainder of the estate. If there are neither descendants nor parents, the decedent's estate is distributed to descendants of the decedent's parents. If there are no descendants, parents, or descendants of parents, then the deceased's property passes to the decedent's grandparents. Or if no grandparents, then the descendants of the grandparents of the decedent. Also, some jurisdictions prohibit individuals from serving on a jury in which they have a certain degree of consanguinity with the defendant. Adoption may or may not be considered at law to create such a bond. In most Western societies, adoptive relationships are considered blood relationships for these purposes, but in others, including both Japan and ancient Rome, it was common for a couple with only daughters to adopt a son-in-law, making the marriage one between adoptive siblings. Religious and traditional law. Under Roman civil law, which early canon law of the Catholic Church followed, couples were forbidden to marry if they were within 4 degrees of consanguinity. In the 9th century the Church raised the number of prohibited degrees to 7 and changed the method by which they were calculated. Eventually the nobility became too interrelated to marry as the pool of non-related prospective spouses became smaller. It was either defy the Church's position or look elsewhere for eligible marriage candidates. In 1215 the Fourth Lateran Council made what they believed was a necessary change to canon law, reducing the number of prohibited degrees of consanguinity from 7 back to 4. The method of calculating prohibited degrees was changed also. Instead of the former practice of counting up to the common ancestor then down to the proposed spouse, the new law computed consanguinity by counting back to the common ancestor. In the Roman Catholic Church, unknowingly marrying a closely consanguineous blood relative was grounds for an annulment. But during the 11th and 12th centuries dispensations were granted with increasing frequency due to the thousands of persons encompassed in the prohibition at 7 degrees and the hardships this posed for finding potential spouses. In 14th century England, for example, papal dispensations for annulment due to consanguinity were relatively few. The connotations of degree of consanguinity varies by context. Most cultures define a degree of consanguinity within which sexual interrelationships are regarded as incestuous. Among the Christian Habesha highlanders of Ethiopia and Eritrea, it is a tradition to be able to recount one's paternal ancestors at least 7 generations away starting from early childhood, because those with a common patrilineal ancestor less than 7 generations away are considered brother and sister, and may not marry. The rule is less strict on the mother's side, where the limit is about 4 generations back, but still determined patrilineally. This rule does not apply to Muslims or other ethnic groups. Ayurveda clearly states that marriage within the Gotra is a consanguineous marriage which can lead to many gestational and genetic problems in the fetus. So it has become a common practice in the Hindu households during pre-marriage discussions to ask the couple's Gotra. Couples of the same Gotra are advised not to marry. The advisors of this system say that this practice definitely helps in reducing the gestational problems and ensures a healthy progeny. Genetic definitions. The percentage of consanguinity between any two individuals decreases fourfold as the most recent common ancestor recedes 1 generation. Consanguinity, as commonly defined, does not depend on the amount of shared DNA within two people's genome. It rather counts the number of meiosis separating two individuals. Because of the effects of pedigree collapse, this does not directly translate into the amount of shared genetic substance. It is common to distinguish first-degree cousins, second-degree cousins, and often also third-degree cousins. Since comparatively few people can trace their full family tree for more than 4 generations, the identity of fourth-degree cousins often cannot be established. Also, at a genetic level, half-fourth cousins typically do not exhibit greater genetic similarity with one another than with any other individual from the same population. Double first cousins are descended from 2 pairs of siblings, and have the same genetic similarity as half-siblings. Conventionally, genetic consanguinity is expressed as defined by Wright with the coefficient of relationship R, where R is defined as the fraction of homozygous due to the consanguinity under discussion. Thus, a parent and child pair has a value of R equals 0.5, siblings have a value of R equals 0.5, a parent's sibling has R equals 0.25, and first cousins have R equals 0.125. As a working definition, unions contracted between persons biologically related as second cousins or closer are categorized as consanguineous. This arbitrary limit has been chosen because the genetic influence in marriages between couples related to a lesser degree would usually be expected to differ only slightly from that observed in the general population. Globally, the most common form of consanguineous union contracted is between first cousins, in which the spouses share 1/8 of their genes inherited from a common ancestor, and so their progeny are homozygous at 1/16 of all loci. Due to variation in geographical and ethnic background in the loci chosen to genotype, there is some 2.4% variation expected. In practice, the technical factors involved are the design of the SNP genotyping platform was used and which software cutoffs were applied. Rates of occurrence. Historically, some European nobles cited a close degree of consanguinity when they required convenient grounds for divorce, especially in contexts where religious doctrine forbade the voluntary dissolution of an unhappy or childless marriage. Conversely, the consanguinity law of succession requires the next monarch to be of the same blood of the previous one, allowing, for example, illegitimate children to inherit. It is estimated that 55% of marriages between Pakistani Muslim immigrants in the United Kingdom are between first cousins, where preferential patrilateral parallel cousin marriage is often favored. Among modern Arabs, the practice of marrying of relatives is a common feature. In the Arab world today, between 40% and 50% of all marriages are consanguineous or between close family members, though these figures may vary among Arab nations. Studies have shown that 67% of Saudi marriages are between close relatives as of 54% of all marriages in Kuwait, whereas 29% of all marriages in Egypt and 18% of all Lebanese were between blood relatives. Genetic disorders. The phenomenon of inbreeding, or endogamy, increases the level of homozygotes for autosomal genetic disorders and generally leads to a decreased biological fitness of a population known as inbreeding depression, a major objective in clinical studies. The offspring of consanguineous relationships are at greater risk of certain genetic disorders. Autosomal recessive disorders occur in individuals who are homozygous for a particular recessive gene mutation. This means that they carry two copies of the same gene. Except in certain rare circumstances, both parents of an individual with such a disorder will be carriers of the gene. Such carriers are not affected and will not display any signs that they are carriers, and so may be unaware that they carry the mutated gene. As relatives share a proportion of their genes, it is much more likely that related parents will be carriers of an autosomal recessive gene, and therefore their children are at a higher risk of an autosomal recessive disorder. The extent to which the risk increases depends on the degree of genetic relationship between the parents, so the risk is greater in mating relationships where the parents are close relatives. But for relationships between more distant relatives, such as second cousins, the risk is lower. A study based on cognitive behaviors among children has revealed the cognitive impairments more common among the subjects having greater value of inbreeding coefficients. The low genetic heterozygosity associated with increased consanguinity in a population increases its susceptibility to infectious pathogens such as tuberculosis and hepatitis. A notable historical example of the detrimental effects of consanguineous marriages is the now extinct House of Habsburg.